Alright, diesel we the people news one more time at it. Never look straight forward, always look around you, be able to protect yourself by any means necessary. Alright? Use your Second Amendment and uh, arm yourself with knowledge. Okay? There's a lot of people out there that is not speaking truth. Okay? Use your brain. Weed out the difference. Okay? That's including me. Right? Because I'm operating in hearsay. So take everything I say with a grain of salt. Okay? This educational purpose is only. Do your own research. Be responsible for yourself and um, quit banking on outside people to do all this work for you. All right? That is your job to protect yourself and your family. Nobody else. Okay? Now, in a corrupt society, I can see how it could be beneficial because, they like to play stupid games for the public to think that there is winners out there. And, you know, just saying, it's misleading. But when you're definitely a pro se, this is when you actually know how muddy the water actually is. Okay? Um, just saying, people, I'm going to stop right there. All right. Because they proceeded forward on lack of subject matter jurisdiction, and I'm just going to say, I am under the belief, but I'm going to go with alleged, okay? This Yonner is alleged tyrant, okay? Now, I understand, uh, you know, uh, but more of anything else, you guys got to think about. If they're not operate within honor, good hands, good faith, are they committing treason and violating your due process? This guy's got $500,000 bond. Well, under the Eighth Amendment, that's a cruel or unusual punishment. Excessive bond. That's excessive. If I make $50,000 a year, that's excessive. That's a violation of the Constitution, y'all. Um, just saying. $500,000 is not very much to a man that makes $50 million. But that $500,000 for a man that makes $12,000 a year, or $12,000 a year, that's excessive. Okay? And I understand that they didn't nitpick it, but when they said excessive bond, it's still excessive. Just saying.
To get into a notice issue for the city. However, if the court is inclined to set it for that date, the city has no availability concerns that they're aware of at this time.
Okay. Clarification, is the prosecutor's office suggesting that they may be calling witnesses for motions to dismiss hearing? Mm-hmm. Well, the city is also, okay. Hold on just a minute. Or did I miss, the city is also bringing motions?
And Your Honor, I believe in addition to the dismissals, Mr. Benshoof mentioned some warrant issues. So I am just anticipating the types of motions that are going to be filed, and I think the city does need to be prepared to subpoena witnesses.
Right. So Mr. Benshoof, it really depends on what your briefing says, what the city receives from you to determine if they are going to need to subpoena witnesses. But what I'm going to do, since your preference is for September 3rd, and the city is not aware of a scheduling issue, I know that's a little bit of a tight timeline. I'll go ahead and schedule the motions hearing for September 3rd. That's a Tuesday, 2024 at 1:30, and I'm assuming we could put it back here in 10:03.
Yes.
Okay, and then give me one moment. Let me set a motion or set up a briefing schedule.
At this point, I do want to point out, if you don't want my interruptions in there, which I don't blame y'all, all right, go to the Legal Beagle. Okay, it'll play the whole 2 hours straight through, and then you can pick and choose through there as you wish. Again, this is for my education, and and what I thought at the time, because I'm listening to him, how he speaks in here. I'm educating myself, and I'm educating myself how the judge speaks. I'm educating myself with the clerk, or the alleged prosecutor there, right? So I'm learning of the speaking abilities in said case, because when I want to step in there, I want to be clear, like this man here. Now on the videos, when you go on the comment of the news station, there was a lot of people saying, well, drug user and this and that, and you ought to be this and ought to be that, due to the false information. But yet, does he even remotely sound like he's actually a drug user? Now, it don't mean he's not, but does he even sound like it? He's in jail, holding his own right now, people. He's in right mind.
Okay. All right. So, Mr. Bench, if we have the motions hearing on September 3rd, that would mean that your brief would be due on August 13th, and the city's brief would be due August 26th. Okay, so let me.
And I'm sorry, Your Honor, you cut out a little bit. Is defendant's brief due August 13th?
Yes, so August 13th for the moving party, August 26th for the response.
Thank you.
I want to pause right there. I don't know what the date is today. But we should be getting pretty close. But sit and think about this. This was a couple of weeks ago, like on that 5th or 6th of August, I believe. And then he had to do all this in jail by August 13th. And meanwhile, theirs has got to be like later in August. Just saying.
And Your Honor, I don't have any phone number by which to contact the prosecutor's office. So if the prosecution is open to pretrial dialogue regarding resolution, global resolution of these charges, I would ask that the prosecution provide me with a phone. And that it needs to be a direct line, because if there's a phone tree that I get into calling from the jail phone, I can't call them.
Okay, so let's see, Ms. Carstensen, can you provide a phone number for Mr. Benchouf to speak to Ms. Outland?
Let me see if I can locate that, Your Honor. One moment.
Okay.
I do have an office number. Would you like me to just provide it on the record?
Yes, so Mr. Bench, it looks like you've got some writing materials there. Okay, go ahead and read that into the record.
Yes, Ms. Outland's office number is 206-684-7756.
Oh, I'm sorry, Ms. Carstensen, would you repeat that?
775.
So in total, it's 206-684-7756.
Lord Bench, can you hand me that trial setting order I just printed? Thank you. Thank you. Okay, so what I'm going to do is have Madam Bailiff bring this around so Mr. Benchoof can sign. Ms. Carsonson, with your permission, can I indicate on the trial setting order that, or I don't know how you want to do this, that city approves via WebEx or something along those lines?
Yes, that's fine. Yes.
Okay. Okay, and then, yes, so if Mr. Bench can sign it, we will, okay. Okay, so Mr. Bench, all I need is your signature at the bottom of this page, and then we will be able to conclude the hearing today. He is.
And just a reminder for y'all out there, right? Always read it, okay? It's designed in some type of way of you're agreeing to their terms, so you got to carefully read these things.
For the record, I still don't agree to the court's jurisdiction. Since I'm incarcerated, I'm not understanding why the court needs my signature to appear when I'm being incarcerated.
Sir, if you don't want to sign it, it's okay. It's standard procedure, just to make sure that you acknowledge that the cases are set for trial and that you understand that this is what the trial setting order says.
So just to show respect to the court, for the record, I understand the court has set the trial date against my wishes, and that the court has set a motions hearing for the 3rd, and so I acknowledge that those were set by the court.
Okay. You know, if you prefer, what you could just, if you write on the line where it says defendant, you don't put your name. You could just say acknowledged by instead of agreeing to it. That's fine.
Now, for educational purposes only, and I'm not an attorney, not giving legal advice. There is no legal signature. All you have to do is put an X there, and he signed. So, I kind of think that's misleading, since there is not really technically a lawful signature. Anything he does on there is going to be considered a signature.
All right. So we've got the cases set for trial now. Let's see, Ms. Carsonson, anything else from the city?
I do not have anything else from the city or for the city, Your Honor, and I actually do have a meeting at 4 p.m. as well.
Okay, I think we're just about done.
Okay, perfect. Thank you.
Okay. All right, Mr. Benchoof, anything else, anything new that you haven't brought up yet before we conclude the hearing?
I think I brought up enough today, Your Honor, and I appreciate your patience.
Okay. All right, sir. Thank you. We're going to conclude your hearing then, and thank you, Marshals. Mr. Marshall. Yes. Okay, Ms. Carsonson, you can go ahead and disconnect from the call. Thank you.
Thank you so much.
I also want to bring out, since he's such a dangerous person, of $500,000. He sure looks really scared for a dangerous guy. She sure looks really scared for a dangerous guy. Of course, I don't know where she's at, but, you know, what do I know? Right? But nobody's in fear for themselves. So why is there a bond of $500,000? Just asking questions.
Have a good day, everyone.
You too. All right, we can go off the record.
Once again, gotta go back.
Allergies.
All right. We finished that one. Now, there's going to be another video in the future. Maybe tonight, maybe not. Don't know. Right now, I feel inclined to do another one, but it's going to be actually another day. Decent Week People News. Bye, y'all.